Hello everyone, welcome to Courts Today by Livelaw, your one-step destination for the latest and fastest legal updates. I'm your host Urvashi Chauhan, bringing you day-to-day happenings, landmark judgments, crucial rulings and expert insights into the world of law. The Supreme Court today raised concerns about the insufficient retirement pensions provided to district judges. The bench, comprising CJI D.Y. Chandrachud and Justices J.B. Pardiwala and Manoj Mishra, was hearing the All India Judges Association case relating to implementation of the Second National Judicial Pay Commission. The CJI today said that some of the district judges retire with a pension of only 15,000 rupees. He recalled a case where a district judge was elevated to the High Court and was suffering from cancer. Because of certain lag in the timing of her elevation, she was not getting pension at par with other High Court judges. The Supreme Court had then intervened in the matter and provided her relief. Referring to this example, the CJI stressed that judges are elevated to the High Court at the age of 56 to 58 years from lower judiciary and retire with a meager pension, making it difficult for them to live a comfortable post-retirement life. Attorney General R. Venkataramani requested for time to address the issue regarding TDS deduction on the allowances paid to judicial officers. While agreeing to defer the hearing, the Chief Justice requested the AG and the Solicitor General to sit down together and find a way out. The Supreme Court has agreed to hear the petition seeking postponement of NEET postgraduate 2024 exam tomorrow. The exam is scheduled for this Sunday. Advocate Anas Tanveer mentioned the petition before CJI D.Y. Chandrachud, who scheduled the hearing for the next day. The petitioners here argue that many candidates have been allocated exam cities that are difficult to reach, with test city allocations made on 31st July and specific centers announced on 8th August, leaving little time for travel arrangements. The petition also requests a disclosure of normalization formula for the 4 sets of question papers to ensure fairness. The petitioners seek rescheduling of the exam, a uniform testing environment by conducting the exam in a single batch, and rectification of examination center allocation issues to ensure equitable and transparent allocation of nearby test centers. The matter will be heard tomorrow. Stay tuned. The Punjab and Haryana High Court has clarified that government employees are not entitled to automatically assume a 5-day work week and claim extra wages for working on Saturdays as a matter of right. The court dismissed petitions filed by employees from various municipalities and government departments in Punjab seeking extra pay for working on Saturdays and holidays. The controversy here began in 1980 when the Punjab government introduced a policy of 5-day work week for its employees, granting weekends off. However, employees in field postings who worked 6 days a week claimed discrimination as they were denied the benefit of 5 days work week like their office-based counterparts. I must tell you here about a Supreme Court judgment from the year 2000 in the case of Municipal Employees Union Sirhind and others versus State of Punjab and others. Here, 2 sets of employees were before the Supreme Court. First, the employees who were deputed for office working and were enjoying Saturdays and Sundays as completely off day. And second, employees of the same department deputed on official duties in the field area and also required to attend such duties on Saturdays or holidays other than the desk work in the office, but were not paid any extra wages. The Apex Court found that duties of these 2 sets of employees are interchangeable because any employee working in the office and enjoying 2 complete off days, that is Saturdays and Sundays, at time of need or exigencies of service could be deputed for the field duty also even on Saturdays and holidays. It was also concluded by the Apex Court that there is a common seniority list of both sets of the employees and that they are all governed by one set of service rules. Thus, it had concluded that equals cannot be treated differently within one category of equals. Now, Justice Sanjay Vashisht of the Punjab and Haryana High Court has disposed of 511 pleas of government employees seeking extra wages for working on Saturdays in various departments of the Punjab government. The court opined that granting of extra wages will depend on the service rules applicable to each employee. And until an employee proves himself to be completely covered with the principle laid down in Sirhin's case, it cannot be concluded that the right of extra wages for working on Saturdays or holidays has already been determined in favor of such employees. The court ruled that to receive extra wages for working on Saturdays, an employee must have a valid document like declaration, order, decree, or award that explicitly grants this entitlement based on a review of their job's specific rules and service conditions. The High Court today directed the Public Works Department of Delhi government to conduct inspection regarding conditions of washrooms and toilets in all jail complexes in the national capital. A division bench comprising Acting Chief Justice Manmohan and Justice Tushar Rao Gadela was dealing with a plea highlighting the issue of lack of facilities for inmates in jail complexes. The bench took note of the report submitted by authorities which said that no incidents were reported regarding manual scavenging by the inmates in any court complex. The report also stated that the condition of the washrooms in jails was not satisfactory and that cleaning work was carried out in toilets voluntarily by the inmates. While some inmates were paid remuneration, others were not being properly paid. The report further highlighted lack of cleaning gears and toiletries for inmates and that some toilets were not in working condition and thus required renovation. Disposing of the plea, the court directed the Delhi government to appoint advocate staff for cleaning of washrooms and toilets in the jail complexes. It has also asked the government to consider, if necessary, seeking assistance from NGOs or employing people on contractual basis for the purpose of cleaning of toilets in jails. It further directed that in all jail complexes where voluntary cleaning work is being done by the inmates, they should be paid suitably minimum wages. It also directed that cleaning gears, gloves, masks, boots and toiletries be provided to the inmates involved in voluntary cleaning work of washrooms and toilets. The Karnataka High Court has stayed the operation of a notification which required the students who have completed their PG medical courses before August 2023 to register for rendering compulsory rural service. The petitioners here submitted that they are students who completed their PG medical courses in August 2023, that is before the Karnataka Compulsory Service by Candidates Completed Medical Courses Amendment Act of 2023 came into force. It was stated that the Amendment Act, which introduced the concept of compulsory rural service, was not retrospective in nature and thus was not applicable to them. Further, it was stated that the impugned notification, which was based on this amendment, was illegal, arbitrary, and without jurisdiction or authority of law and deserved to be quashed. As the government advocate sought time to file an objection to the petition, a single-judge bench of Justice S.R. Krishna Kumar said that in the meantime, the impugned notification would be stayed. In another update, the Delhi High Court has reiterated that an FIR has to be mandatorily registered whenever a person dies in a police encounter, which is alleged to be fake. Justice Neena Bansal Krishna dismissed Delhi Police's plea against a trial court order which directed registration of FIR against a police raiding team in respect of death of a man in a police encounter in 2013. The Lieutenant Governor had ordered a magisterial inquiry into the incident. The inquiry concluded that no illegal act had been committed by the members of the police team. Therefore, the father of the deceased filed an FIR for the offence of murder and under the Arms Act. It was his case that his son had been murdered intentionally by the police. He alleged that none of the three accused persons who were allegedly running to escape from a car when the incident took place had fired towards the police and none of the police officials received any injury. He further alleged that his son was mercilessly beaten by the police officials with some blunt object and thereafter they fired upon the car only to save themselves. The police claimed that SDM's inquiry concluded that officers fired in self-defense after being shot at by the car's occupant. The High Court, now upholding the trial court order, relied on plethora of judgments and reiterated that in a society governed by law, extrajudicial killings must be properly and independently investigated so that justice may be done. The court noted that investigations must determine whether the incident was a murder or an encounter. It observed that vehicles' tires in this case were not deflated and firing was aimed at the window and not the tires. No police officials were injured despite claims of being shot at, and the circumstances of the victim's death here needed to be clarified. When the police submitted that no criminal investigations can be carried out against the police officer without grant of sanction under Section 197 CRPC, the court said that the provision does not extend its protection cover to every act or omission done by a public servant in service and is only for those acts which are done by a public servant in discharge of official duty. Thus, the court refused to quash the FIR against the policemen. And lastly, let me tell you, today in the ongoing monsoon session of the Parliament, the Union Minority Affairs Minister Kiren Rijiju introduced the Waqf Amendment Bill 2024 in the Lok Sabha. It proposes to bring approximately 40 amendments to the existing Waqf Act of 1995 and which was amended in 2013. The proposed amendments introduce stricter regulation for Waqf creation and management, including detailed reporting requirements and involvement of government auditors. Key changes include replacing the survey commissioner with collector for surveys, ensuring registration only with a valid deed, and expanding the representation on Waqf board to include women and non-Muslims. After an intense debate, the House referred the bill to a joint parliamentary committee for wider scrutiny after the minister agreed to it. As per the statement of objects and reasons, it has been found that the 1995 Act has not proved effective in improving the administration of Waqf. However, the members of the opposition have vehemently opposed the bill. Member of Parliament from Kerala, K.C. Venugopal, termed the bill draconian and fundamental attack on constitution. TMC legislator Sudeep Bandyopadhyay from Kolkata termed the bill as violation of Articles 14, 25 and 26, which protects equality and freedom of religion. The opposition has stated that the bill must be referred to Parliamentary Standing Committee to address the concerns, and especially because the bill has been tabled without proper consultation. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.